Good afternoon, and thank you for attending this live session on the rights and responsibilities of employees with disabilities. This presentation is being recorded, and I would like to ask everyone to please remain on mute until the end. So I also wanted to mention that I will be reading the slides to accommodate any viewer with a visual impairment. And without further ado, let's get started. So before we begin the presentation, I'd like to share a few facts about DNL. We're located at 442 Century Lane in Holland and have served Allegan and Ottawa counties for the past 31 years. The disability community is very diverse, and we'll talk more about what is meant by that, what is meant by all disabilities in just a moment. So in 2020, DNL provided 3,419 critical services to 784 people. Essentially, we help people access resources and to develop the skills they need to live independently. We also partnered with over 200 businesses, schools, and organizations, and we educate the community on the benefit of including with disabilities. You'll also notice the number 15 on this slide. That is because we're considered a Center for Independent Living, and we're one of 15 in the state and almost 400 in the country. So what's a disability? The ADA essentially covers disability under 7 categories. So the key thing here is that in order to be considered a disability, along with being a physical, mental, or emotional impairment, it must significantly limit a major life activity, such as seeing, hearing, breathing, learning, walking, communicating, decision-making, etc. When we think of physical disabilities, some examples are a spinal cord injury, multiple sclerosis, or arthritis. Sensory is pretty self-explanatory, visual and hearing primarily. Cognitive impairments constitute things like learning disabilities, attention deficit hyperactivity disorder, and brain injury. Intellectual impairments, which sometimes are confused with cognitive disabilities. Some examples would be Down syndrome or Fragile X syndrome. And then developmental impairments would be things like cerebral palsy, autism, and fetal alcohol syndrome. Mental illness, as you can probably imagine, we're thinking of impairments like depression, bipolar, anxiety. And health-related, this covers a wide gamut. It could be cancer, a heart condition, any one of those types of issues. Could even be like a food allergy would constitute a health-related disability. Okay, so I think I went one slide too far. Oh, I did not. Okay. So do you qualify for ADA protection? Well, first of all, you must make sure that you qualify as a person with a disability according to the Americans with Disabilities Act. Title I of the ADA covers employment, and this is where employees with disabilities find their protections. So there are typically 3 factors that have to be present when considering whether you're protected under the ADA, under Title I of the ADA. So you have to have a physical, mental, or emotional impairment that significantly limits a major life activity. We discussed that just a moment ago. And then you have to have the necessary skills and training to perform the duties. So for example, if you were a cashier, you would need to have the ability to learn and operate a cash register, problem solve customer and computer issues, communicate effectively, and provide customer service. You also must be able to perform the essential functions of the job. And essential functions are essentially your primary job duties or the reason the job exists. So which employers are covered by the ADA? As you can see, most employers have to adhere to the ADA. The list here covers the majority of those employers. Religious entities, actually, if they have 15 or more employees, are also covered by the ADA, as long as we're not talking about the role of, let's say, a pastor or a priest or anyone whose position is not primarily to lead worship or provide faith-based instruction, but a secretary, janitor, others whose primary role is not to provide faith-based instruction would be protected under the ADA, even if you work for a faith-based organization. The only other entity that wouldn't be required, it's really not an entity, but independent contractors are not covered by the ADA for the purposes of Title I. So do you have to disclose? Well, first you want to consider when and to whom you disclose, because that's really up to you. You're not legally required to disclose your disability, but if you don't, you cannot request a reasonable accommodation either. So there are 3 situations when disclosure occurs during the application or interview process, or once you're hired, or after you've been working for a while and you determine that you need an accommodation in order to continue to be successful. If you need an accommodation, you should disclose to your human resources department. Just keep in mind that disclosing can help you avoid disciplinary action and keep your job. So what should you share when you disclose? Only what is necessary to acquire the accommodation that you need. Sometimes people have more than one disability. If only one disability is impacted, I would suggest you only share information related to the disability that is impacted. So that means just sharing the basics. For example, I might say, I have a reading specific learning disability. This means I struggle to comprehend what I'm reading. However, if the same information is spoken or read to me, I can easily understand it. A reasonable accommodation would be to record my daily tasks on my phone where they can be read back to me as needed. Keep in mind that once you disclose, the employer can then begin to ask more questions about your disability. Prior to that, they are not allowed to ask you questions about your disability or whether or not you even have a disability prior to being hired. So just keep that in mind, that it does open up the door for questions. And then employers are only required to make accommodations, reasonable accommodations, for a known disability. So if you were reprimanded for a mistake at work prior to your employer knowing about your disability, the employer does not have to rescind that discipline. Okay, so any write-ups, verbal reprimands do not have to be rescinded in your file prior to the employer knowing about your disability and you therefore disclosing that disability. So another point here to make is that reasonable means any changes to the duties or work environment that will allow a qualified employee with a disability to perform the essential functions of the job. Remember, you must have the necessary skills and training required for the job in order to be considered qualified. So how do you request a reasonable accommodation? So first you have to decide how you will make your request. Will it be in person or in writing? Written requests can be an email or a formal letter. I would recommend, though, if you do so in person, that you follow it up with a written copy of that request, simply because if it wasn't written down, it wasn't said. You should make your accommodation or your request to the human resource manager or someone in human resources if a human resources department exists. And the reason being is that those who work in human resources typically have a bit more training and knowledge when it comes to the ADA and what the company's responsibilities are. However, if you don't have an HR department, I would suggest that you disclose to the highest level supervisor. Because unfortunately, a lot of frontline supervisors, depending on the employer, depending on the type of work, don't always have the legal knowledge surrounding the ADA and Title I. So how are you going to make this request? You're going to simply explain why you need an accommodation and offer your accommodation ideas. So prior to this, I think in the slide before I said, just some basic information. So briefly describe your disability and which tasks are difficult for you to perform as a result. Provide accommodation suggestions based on your past experience. Could be experience in another job with similar tasks. Could be other life experiences where you've had to complete a similar duty or task that were unwork related, but a particular accommodation worked well for you. Follow up. You want to provide a deadline for when you would like a response, and follow up right away if you do not receive a response by that date. And keep in mind that you are going to be responsible for monitoring whether or not the accommodations are actually working. And remember that abilities can change over time. An accommodation that worked initially may not always be effective. And there's no one size fits all solution. So essentially what that means is no two people with the same disability will experience it in the same way. So accommodations there can be an ebb and flow to them. Things can change. There is a link on the side to askjan.org, which is the Job Accommodation Network. You may want to note that. It can be a great resource when you want to learn more about your rights and responsibilities and what types of accommodations will work best for you as an employee with a disability. So can your employer refuse an accommodation request? Typically, no, they can't be denied. But again, keep in mind, you must have a disability that significantly limits a major life activity in order to be covered under the ADA. You must also satisfy the employer's job requirements for the position, such as possessing the necessary skills, training, education, or even licensing. And all those things can be found in the job description, typically under qualifications, what's required for the position. And you also have to be able to perform the essential functions of the job. We said a few minutes ago that those are the primary duties or the reason the job exists. Now, undue hardship. This can be a tricky one. So essentially, an employer can claim undue hardship if the accommodation, the reasonable accommodation request, is either too administratively or too expensive to provide. So an example where the first example has to do with a reasonable accommodation request and would not be considered an undue hardship. So the first example is a bank teller with arthritis requests the use of a sit-lean chair while assisting customers. The bank has a policy against the use of chairs at teller windows. However, once the employee discloses, the employer must provide this or another equally reasonable accommodation. Keep in mind, once the employee discloses, the employer can begin to ask for medical documentation confirming the disability if it's not obvious. Okay. Now, arthritis may or may not be obvious, but that is the key there. They can ask for an additional information, but it's only when the disability is not obvious. Now, a good example of an undue hardship would be the following. Excuse me. An employee with a reading-specific learning disability receives a daily task list in writing and requests that the employer provides an expensive screen reading software. Because the task list is the only required reading for the job, the employer instead offers to record task instructions and provide that recording to the employee. So undue hardship comes in here in terms of the cost of the screen reading software. And there isn't any level of So let's say an entity, a business, an employer makes a profit of $1 million a year. There's no percentage or anything like that based on their profit margin that says, okay, you make $1 million a year, you can afford to provide accommodations, the cost of accommodations up to a certain level. That doesn't really exist. The employer simply has to be able to prove that it was too expensive to provide and prove that they provided an equally reasonable accommodation. So, and which they did in that example. However, an example of definitely an undue hardship, straightforward undue hardship would be something like a convenience store clerk with multiple sclerosis requests that he be allowed to go from working full-time to part-time as a reasonable accommodation because of his disability. The store assigns 2 clerks per shift, and if the first clerk's hours are reduced, the second clerk's workload will increase significantly beyond his ability to handle his responsibilities. The store determines that such an arrangement will result in an inadequate coverage to serve customers in a timely manner, keep the shelves stocked, and maintain store security. So this is a situation where it provides more of an administrative hardship on the organization. You can easily see going from full-time to part-time is significant. And if each shift requires 2 clerks, it's just really not reasonable. So our third situation where an accommodation can be refused is with regard to health and safety concerns. For example, a forklift driver has epilepsy, and although she or he takes medication to control their seizures, the medication doesn't completely eliminate the possibility of a seizure. Because the individual is driving heavy equipment and potentially could run into other employees, do damage to the business, the product, whatever it might be, the employer can claim that there is a health and safety concern here. So there are a variety of these that exist. There are a variety of reasons why an employer might claim health or safety concern. But essentially, they're typically relegated to significant medical issues. And since this was a quick DNL live session, that is the end of the presentation. And if you have questions, you may feel free to ask them now, or you can email me at stacy@dnlakeshore.org.
Stacy.
Yeah.
Hello.
Hi.
Jerry Dion.
How are you?
I'm good. How are you?
Good.
This is good. I don't usually work in this area of helping folks with kind of reasonable accommodations from their employer. Can you say anything about medical benefits and employment of people with disabilities? That's a broad category, but generally, is there some parameters that the ADA speaks to about that?
Well, I will say this, that there's a lot of misconception that people with disabilities will cost employers more from a health benefit perspective. And that's simply not true.
Mm-hmm.
You know, I mean, I know there's a lot of employers are doing a lot of different things health benefit wise these days, but essentially, you know, we still have quite a few employers who are offering some type of health benefit. It is not more costly for employers. With the elimination of pre-existing conditions, I think that helps too. Beyond that, it's hard for me to answer or provide any more information without something specific.
Yeah. So if an employer says, yeah, and maybe this is law about when employers must provide medical benefits or not. So a person is considered, so they only offer to say full-time employees who are considered anyone who works 30 or more hours a week or is paid for 30 more hours a week.
Mhm.
If they work less than that, can an employer still provide medical benefits to any employees, but particularly people with disabilities? Or are they not legally obligated, or are they not even legally obligated to provide benefits even for full-time employees?
I don't think, I think an employer can choose not to provide, I believe, health insurance at all.
Yeah.
If that's their policy, they can ask their employers to access health benefits through the marketplace
Mhm,
or somewhere else.
mhm,
Typically, I would say most employers are just going to set a policy and follow it. So if full-time is 30, 32 hours and above, that's who receives health benefits. Those are the individuals. Now, obviously, most employers, they make their own policies, their own rules. They could choose to provide them to someone who works less than 30 hours. But then I would imagine that their policy would then state that they are providing benefits to people who work any number of hours or who work 20 hours or more. I
mhm.
don't really feel like, as far as I know, the ADA doesn't weigh
Okay.
in a lot on that. I would have to look that up though. I haven't heard that it
Mhm,
weighs in
mhm.
on, because those are decisions that an employer can make
Yeah,
on their
yeah,
own.
yeah. And I would guess with, you know, the Affordable Care Act and that kind of stuff, the availability of insurance in the marketplace for people with pre-existing conditions, that kind of relaxed some of those concerns, I
Mhm.
would imagine.
Yep,
So,
yep,
all
yep.
right, all right. Okay.
Other questions?
So in the, when can an employer refuse an accommodation request? uh, Undue hardship, health and safety concerns,
Mhm.
those are on the part of the employer. They're not on the part of the employee, right? Who's requesting an accommodation. Those are not, those don't go both ways. I don't know a situation when they would necessarily go both ways, but
No, no. So, like the example I gave with the store clerk. Um, Obviously it's a store clerk saying, hey, I want to go down to part-time. My disability is worsening. And I just can't work full-time anymore. And the employer is saying, look, from an administrative standpoint, we can't do this. We have to have 2 full-time people on each shift. So now people have taken employers to court for it. But I would say that just on the surface, in a situation like that, an employer is going to have a really good case.
mhm,
Um, and then with the health and safety standards, um, again, I mean, in a forklift is a common example just because we see those in a lot of manufacturing environments, things like that, where there could be dangerous situations. And so the employer is not only trying to protect the other employees and their property, but they're also trying to protect themselves against maybe a lawsuit claim if the employee with a disability was injured as a result.
mhm.
So now the Department of Transportation, um, as a federal entity, they can simply, if you have diabetes and you require insulin, they can deny you employment just on that base.
Hmm.
You don't, I mean, it doesn't matter if you prove that, oh, it's been controlled for years, I've never had any type of seizure, never had any type of reaction, or not a seizure per se, but like gone into had any memory loss, whatever it might be. But simply on the basis that you require insulin, they can refuse to hire you.
Hmm.
So, mhm.
Hmm.
Yep.
Okay.
So but I would also imagine that's why a lot of people don't disclose, especially when you're
Yeah.
working in again, a manufacturing environment.
Yep.
People are saying, I need my job. I'm just going to hope that,
Yep.
my medication takes care of it and nothing happens.
Mhm, mhm.
But obviously that's not the way to go. I mean, the way to go would be maybe to request a different position or not apply to a better position initially. So,
Yeah, yeah. Okay.
Yep.
All right. Good.
yep. So that was just short and sweet, but
Good. Well, very helpful.